We all have a multiplicity of characteristics that make us who we are. And I think it's at times, particularly if you're not very introspective, which I'm not, to reflect.
I don't think you can sit on the Supreme Court of Canada and not be introspective.
Trust me. Yeah.
When you look at the progress that has been made in engaging women and retaining women in the legal profession today, do you see it as having come from A to Z, or is there, in your mind, still this road that must be traversed?
Yeah, I think there's a huge amount of work to be done. But again, if we reflect sort of collectively as to how it has happened that women have carved such an important place for themselves in the law and the legal profession. It's been a process that has profoundly transformed women into occupying their full professional space, but it's also a process that has profoundly transformed the law. And I think the reason also women joined the profession in the numbers and with the kind of power that they are demonstrating today is because the law became a very relevant environment for women. I'm not sure that it had been, certainly prior to the Canadian Charter of Rights and Freedoms. They were little ghetto areas of the law where I think women sense profoundly the relevance of the injustice that they suffered as a result of very unfair laws. I think in family law, in criminal law, that was certainly the case. But the law became, I think, a relevant environment, felt very profoundly by women and by many other groups who, I think, in the last 30 years in this country, have insisted that the law be about justice,
yes,
which was not always the case.
When you were appointed to the Supreme Court of Canada in 1999, you talked about some of the challenges that you'd faced earlier and the acceptance that you'd felt. What was that world like?
Well, again...
Other than not introspective.
Well, again, not unlike Osgoode Hall Law School, the Supreme Court of Canada was hugely welcoming to me when I joined. Now, that in part reflected the fact that others before me, I think, had made that environment much more, let's put it this way, much more open to pluralism than it had been historically. They had been women there before, and very spectacular ones. In fact, I should mention, just this morning I had an email from Claire Leroux-Dubé, and I will write back to her to say that I saw all of you here today. I think she will be very nostalgic for not having an opportunity to meet with many of you. People like her, like Bertha Wilson, like Beverly McLaughlin, had, I think, already made the kind of inner circles of the court, the deliberation process, a process where there was no reason for women, or frankly, for anyone who didn't fit the traditional, very traditional role model of a Supreme Court of Canada judge, feel very at home and very welcome. Now, the deliberation process of the Supreme Court is a very particular environment. It's I've served at all levels of court. I was a trial judge, I was an appellate court judge, and I think at the level of the Supreme Court, the environment is profoundly different. For those of you who are lawyers, which is, I think, a lot of people in this room, you will appreciate that inevitably, I think, in the legal profession, we specialize. We develop very, very acute expertise in some areas. By the time you get to the Supreme Court of Canada, quite late in your professional development, you have to learn to become a generalist all over again. That's very challenging, particularly if you can appreciate the areas of laws that are developed or litigated in the federal court system. If you come from the provincial appellate court system, all of a sudden you discover things like intellectual property, immigration law, very challenging. You have to start again. It's a very humbling experience. Think from first principles. You have to trust the quality of the litigation and the arguments that are presented before you. So it's a very complex and unique environment. But as I said, I think it has been extremely energized or educated by the quality of advocacy in particular that was done in charter cases, and more specifically by the many lawyers who argued cases for leave before the Supreme Court. And I want to say more about that, I think,
sure,
as we go along.
absolutely. I want to talk about your role with the United Nations as the High Commissioner for Human Rights. I mean, you were given that opportunity, just as Darfur was seizing headlines around the world for human rights abuses. You were dealing with what was happening in Chechnya, in Colombia, in Congo, Uzbekistan. There was sort of a national explosion, and if not an explosion, but an awareness of human rights abuses around the world that perhaps there hadn't been before. And some called your position, what was it, the job from hell, because you were dealing with so many things. How did you view that?
Well, yeah, it was at times
the job from
hell. Although I have to say, if that's what hell is like, it was full of angels. They were amazingly courageous, particularly NGOs, civil society actors, human rights defenders, who carried an enormous burden, particularly in field work in the various countries that you've mentioned. The job of the High Commissioner itself is hugely frustrating. Because you operate in a political environment that is, I think is fair to say, at times extremely hostile to the human rights agenda, which is not all that surprising. I mean, many of you here who have been equality advocates and so on understand the, at times, very strong resistance that governments put forward when claims, grievances are brought to them. Human rights law is basically the body of law that stands between the government and its people. I mean, that's, to put it in a nutshell, it deals in this, very much in this relationship between the government and the governed. Now, to try to penetrate that relationship as an international actor is very difficult because of claims of state sovereignty. And so you're the last person that any government wants to talk to about this intimate relationship between the government and I always say, and its people, because it's not just its citizens, it's all the people under its control, its authority, its jurisdiction, not just its actual citizens. So it's an environment, I think, for an international civil servant, for an international actor, it's probably the field of work that is the least welcome, despite the rhetoric, of course. Everybody's in favor of human rights, equality, dignity, freedom, until you start talking to them pretty seriously about what it means.
That must have been very challenging to work within those political constraints. I mean, how do you, and I don't know if you did, how do you break that down?
Well, first of all, there's 192 member states in the United Nations. I don't think there's a single one that has a perfect human rights record.
Right.
But I don't think they can all be approached with the same formula. You know, in human rights advocacy, there are various techniques. Naming and shaming, in some cases, is the only option. In other cases, there are other forms of engagement. Sometimes all you can hope to achieve is not a drastic change in government policy, but it's trying to persuade the government, for instance, not to execute a minor, a single person. And in some cases, that's the ambition, I think, that is worth pursuing, because that's the only one in which you have a chance to make a difference. And it's not nothing to make the difference in one person's life, even though, again, when you work internationally, it looks like a very modest ambition. But in some cases, realistically, that's as far as you're going to go at this time in the history of a particular country. In other circumstances, you can make tremendous progress. My own sense, working in human rights internationally, is that, you know, we're going to be on December 10th, we're going to be celebrating the 60th anniversary of the Universal Declaration of Human Rights. The United Nations has constructed an extremely impressive normative edifice. It has all the right principles, norms, standards, but the actual implementation on the ground is virtually non-existent. It's a body of law that doesn't carry a set of remedies or any form of kind of compulsory